Hey guys, today we're diving into a crucial topic for business owners and investors alike: minority oppression of shareholders. This is especially relevant in Singapore, where the law provides certain protections under the Companies Act to ensure that minority shareholders are not unfairly treated by the majority. If you're a shareholder, director, or just someone curious about corporate governance, stick around to learn what constitutes minority oppression, the legal provisions involved, and the remedies available to those who face such oppression. So what exactly is minority oppression? Minority oppression occurs when the majority shareholders or those in control of a company act in a way that unfairly prejudices the rights or interests of the minority shareholders. In practical terms, this could be exclusion from important decisions, dilution of shares, or even mismanagement of the company. In Singapore, minority oppression is taken seriously, and the Companies Act provides safeguards to protect minority shareholders. The key provision in the Companies Act concerning minority oppression is Section 216. This section provides relief when the company's affairs are conducted in a manner that is oppressive, unfairly discriminatory, or prejudicial to one or more shareholders, including the disregard of their interests as shareholders of the company, or some act of the company has been done or is threatened, or that some resolution of the shareholders has been passed or is proposed which unfairly discriminates against or is otherwise prejudicial to one or more shareholders. This section essentially empowers the courts to step in when there is evidence of such misconduct, providing remedies to protect the aggrieved minority shareholders. Let's look at some common examples of minority oppression in Singapore. Number one, exclusion from decision making. If the majority shareholder runs the company without consulting or informing the minority shareholders about important business decisions, this could constitute oppression. For instance, if the company decides to sell off a major asset without informing all shareholders, it could prejudice minority interests. Number two, dilution of shareholding. Another common example is when majority shareholders issue new shares at an undervalue to dilute the minority's stake in the company. This is done to reduce their voting power or financial interest. Number three, mismanagement of company assets. If the majority shareholders mismanage the company, either by engaging in risky transactions or siphoning off the company funds for personal use, the minority may have a case for oppression. Number four, unfair removal of directors. Minority shareholders who hold board positions may face unfair removal or exclusion from key meetings, preventing them from exercising their rights within the company. If you are a minority shareholder facing oppression, you have a few legal remedies available under Section 216 of the Companies Act. The first are court orders. The courts in Singapore can issue a wide range of orders to provide relief. This may include directing or prohibiting any act or cancel or varying any transaction or resolution. Number two, the court order could regulate future conduct of the company's affairs. For example, the court may require certain decisions to be made only with the approval from all shareholders. Number three, the court order could authorize civil proceedings to be brought on behalf of the company if it is in the company's best interests. Number four, the court order could provide for a buyout of shares. The court may order that the majority shareholders buy out the minority shareholders at a fair value, ensuring that the oppressed shareholders exit the company with compensation. Number five, winding up of the company. In extreme cases, the court may order that the company be wound up if it is deemed that the oppression is so severe that continuing the business is no longer feasible. Now, winding up simply means closing down the company. Now, let's move on to injunctions. The minority shareholders may apply for an injunction to prevent further oppressive actions by the majority, such as an injunction to prevent them from issuing new shares or taking unauthorized loans. Minority oppression is a serious issue that can affect the rights and interests of shareholders in any company. It is important to understand that the Companies Act provides strong protections, but navigating these legal waters requires a solid understanding of the law and how to build a strong case. If you are a minority shareholder feeling marginalized or unfairly treated, don't hesitate to seek legal advice early on. It could make all the difference. If you found this video helpful, don't forget to like, share, subscribe, and comment. As always, let me know in the comments below if you have any specific questions or topics you'd like me to cover next time. Thank you for watching, and I'll see you in the next video.